We will continue argument this morning in case number 11393, National Federation of Independent Business versus Sebelius, and case 11400, Florida versus the Department of HHS. Mr. Clement.
Mr. Chief Justice, and may it please the Court, if the individual mandate is unconstitutional, then the rest of the Act cannot stand. As Congress found and the federal government concedes, the community rating and guaranteed issue provisions of the Act cannot stand without the individual mandate. Congress found that the individual mandate was essential to their operation. And not only can guaranteed issue and community rating not stand, not operate in the manner that Congress intended, they would actually counteract Congress's basic goal of providing patient protection but also affordable care. If you do not have the individual mandate to force people into the market, then community rating and guaranteed issue will cause the cost of premiums to skyrocket. We can debate the order of magnitude of that, but we can't debate that the direction will be upward. We also can't debate.
That may well be true. The economists are going back and forth on that issue, and the figures vary from up 10% to up 30%. We're not in the habit of doing the legislative findings. What we do know is that for those states that found prices increasing, that they found various solutions to that. In one instance, we might or may not say that it's unconstitutional, Massachusetts passed the mandatory coverage provision. But others adjusted some of the other provisions. Why shouldn't we let Congress do that if, in fact, the economists some of the economists prove right that prices will spiral? What's wrong with leaving it in the hands of the people who should be fixing this, not us?
Well, a couple of responses, Justice Sotomayor. First of all, I think that it's very relevant here that Congress had before it, as examples, some of the states that had tried to impose guaranteed issue and community rating and did not impose an individual mandate. And Congress rejected that model. So your question is quite right in the saying that it's not impossible to have guaranteed issue and community rating without an individual mandate. But it's a model that Congress looked at it and specifically rejected. And then, of course, there's Congress's own finding. And their finding, of course, this is finding I, which is 43A of the government's brief in the appendix. Congress specifically found that having the individual mandate is essential to the operation of guaranteed issue and community rating.
That's all it said it was essential to. I mean, I'm looking at it. The exchanges, the state exchanges, are information gathering facilities that tell insurers what the various policies actually mean. And that has proven to be a cost saver in many of the states who have tried it. So why should we be striking down a cost saver when if what your argument was that Congress was concerned about costs rising?
Well,
why should we assume they wouldn't have passed an information?
I think a couple of things. One, I would think you sort of have to take the bitter with the sweet. And if we're going to look at Congress's goal of providing patient protection but also affordable care, we can't, I don't think it works to just take the things that save money and cut out the things that are going to make premiums more expensive. But at a minimum.
I guess the bottom line is, why don't we let Congress fix it?
Well, let me answer the bottom line question, which is no matter what you do in this case, at some point there's going to be, if you strike down the mandate, there's going to be something for Congress to do. The question is really, what task do you want to give Congress? Do you want to give Congress the task of fixing the statute after something has been taken out, especially a provision at the heart, or do you want to give Congress the task of fixing health care? And I think it would be better in this situation.
If we strike down one provision, we're not taking that power away from Congress. Congress could look at it without the mandatory coverage provision and say, this model doesn't work, let's start from the beginning. Or it could choose to fix what it has. We're not declaring one portion doesn't force Congress into any path.
And of course that's right, Justice Sotomayor, and no matter what you do here, Congress will have the options available. So if you strike down only the individual mandate, Congress could say the next day, well, that's the last thing we ever wanted to do, so we're going to strike down the rest of the statute immediately and then try to fix the problem. So whatever you do, Congress is going to have options. The question is...
There's such a thing as legislative inertia, isn't there?
Well, that's exactly what I was going to say, Justice Scalia, which is, I think the question for this Court is we all recognize there's legislative inertia, and then the question is, what's the best result in light of that reality? And
suggesting that we should take on more power to the Court.
No,
Congress would choose to take one path rather than another. That's sort of taking on to the Court more power than one, I think, would want.
And I agree. We're simply asking this Court to take on straight on the idea of the basic remedial inquiry into severability, which looks to the intent of the Congress that passed.
Well, I want to ask you about that. Why do we look to the? You sure we look to the intent of the Congress? I thought that sometimes Congress says that these provisions all the provisions of this act will be severable, and we ignore that when the act really won't work. When the remaining provisions just won't work. Now, how can you square that reality with the proposition that what we're looking for here is what would this Congress have wanted?
Well, two responses, Justice Scalia. Well, you can look at this Court's cases on severability, and they all formulate the test a little bit differently.
Yeah, they
but
sure
every
do.
one of them talks about congressional intent. But here's the other answer.
That's true, but is it right?
It is right. And here's how I would answer your question, which is when Congress includes a severability clause, it's addressing the issue in the abstract. It doesn't say, boy, no matter which provisions you strike down, we absolutely positively want what's left.
All right. Then the consequence of your proposition, would Congress have enacted it without this provision? Okay, that's the consequence. That would mean that if we struck down nothing in this legislation but the what's it called, the Cornhusker kickback, okay, we find that to violate the constitutional proscription of venality, okay? When we strike that down, it's clear that Congress would not have passed it without that. It was the means of getting the last necessary vote in the Senate. And you're telling us that the whole statute would fall because the Cornhusker kickback is bad. That can't be right.
Well, Justice Scalia, I think it can be, which is to say the basic proposition, that it's congressional intent that governs. Now, everybody on this Court has a slightly different way of divining legislative intent. And I would suggest the one common ground among every member of this Court, as I understand it, is you start with the text. Everybody can agree with it.
So, Mr. Clement, let's start with the text. And you suggest, and I think that this is right, that there is a textual basis for saying that the guarantee issue and the community rating provisions are tied to the mandate. And you pointed to where that was in the findings. Is there a textual basis for anything else? Because I've been unable to find one. It seems to me that if you look at the text, the sharp dividing line is between guarantee issue community ratings on the one hand, everything else on the other.
Well, Justice Kagan, I'd be delighted to take you through my view of the text and why there are other things that have to fall. The first place I'd ask you to look is finding J, which is on the same page, 43A. And as I read that, that's a finding that the individual mandate is essential to the operation of the exchanges. But there are other links between guaranteed issue and community rating and the exchanges. And there, I think it's just the way that the exchanges are supposed to work, and the text makes this clear, is they're supposed to provide a market where people can compare community-rated insurance. That's what makes the exchanges function.
Although the exchanges function perfectly well in Utah, where there is no mandates. They function differently, but they function. And the question is always, does Congress want half a loaf? Is half a loaf better than no loaf? And on something like the exchanges, it seems to me a perfect example where half a loaf is better than no loaf. The exchanges will do something. They won't do everything that Congress envisioned.
Well, Justice Kagan, I think there are situations where half a loaf is actually worse, and I want to address that, but more broadly. But before I do that, if I can stick with just the exchanges, I do think the question that this Court is supposed to ask is not just whether they can limp along and they can operate independently, but whether they operate in the manner that Congress intended. And that's where I think the exchanges really fall down, because the vision of the exchanges was that if you got out of this current situation where health insurance is basically individualized, priced based on individualized underwriting, and you provide community rating, then it's going to be very easy for people to see, okay, well, this is a silver policy, and this is a bronze policy, and this is a gold policy, and we can, I can just pick which insurer provides what I think is going to be the best service based on those comparable provisions.
Mr. Clement, you just said something which you say a lot in your brief. You say the question is the manner in which it would have operated. And I think that that's not consistent with our cases. And I guess the best example would be Booker, where we decided not to sever provisions, notwithstanding that the sentencing guidelines clearly operate in a different manner now than they did when Congress passed them. They operate as advisory rather than mandatory.
Well, but Justice Kagan, I actually think Booker supports our point as well, because there are two aspects of the remedial holding of Booker. And the first part of it, which I think actually very much supports our point, is where the majority rejects the approach of the dissent, which actually would have required nothing in the statute to have been struck, not a single word. But nonetheless, this Court said, boy, if you do that, then all of the sentencing is basically going to be done by a combination of the juries and the prosecutors, and the judges are going to be cut out. And the Court said the one thing we know is that's not the manner in which Congress thought that this should operate. Now, later they make a different judgment about which particular provisions to cut out. But I do think Booker's consistent with this way of looking at it. Certainly consistent with Brock, the opinion that we rely on, because there the Court only reached that part of the opinion after they'd already found that the must-hire provision operated functionally independent from the legislative veto.
But Mr. Clement, there are so many things in this Act that are unquestionably okay. I think you would concede that reauthorizing, the Indian Health Care Improvement Act, changes to the black lung benefits, why make Congress redo those? I mean, it's a question of whether we say everything you did is no good, now start from scratch, or to say, yeah, there are many things in here that have nothing to do, frankly, with the affordable health care, and there are some that we think it's better to let Congress to decide whether it wants them in or out. So why shouldn't we say it's a choice between a wrecking operation, which is what you are requesting, or a salvage job, and the more conservative approach would be salvage rather than throwing out everything?
Well, Justice Ginsburg, two kinds of responses to that. One, I do think there are some provisions that I would identify as being at the periphery of this statute, and I'll admit that the case for severing those is perhaps the strongest. But I do think it's fundamentally different, because if we were in here arguing that some provision on the periphery of the statute, like the Biosimilars Act or some of the provisions that you've mentioned, was unconstitutional, I think you'd strike it down and you wouldn't even think hard about severability. What makes this different is that the provisions that have constitutional difficulties or are tied at the hip to those provisions that have the constitutional difficulty are the very heart of this Act. And then if you look at how they are textually interconnected with the exchanges, which are then connected to the tax credits, which are also connected to the employer mandates, which is also connected to some of the revenue offsets, which is also connected to Medicaid, if you follow that through, what you end up with at the end of that process is just sort of a hollow shell. And at that point, I think there is a strong argument for we can't possibly think that Congress would have passed that hollow shell without the heart.
Well, but it would have passed parts of the hollow shell. I mean, a lot of this is reauthorization of appropriations that have been reauthorized for the previous 5 or 10 years, and it was just more convenient for Congress to throw it in the middle of the 2,700 pages than to do it separately. I mean, can you really suggest? They cite the Black Lung Benefits Act, and those have nothing to do with any of the things we're talking about.
Well, Mr. Chief Justice, they tried to make them germane, but I'm not here to tell you that, surely there are provisions that are just looking for the next legislative vehicle that's going to make it across the finish line, and somebody's going to attach it to anything that's moving. I'll admit that. But the question is, when everything else from the center of the Act is interconnected and has to go. If you follow me that far, then the question is, would you keep this hollowed-out shell?
But I'm
Well,
still
but it's
not
not-
sure what is the test, and this was a colloquy you had with Justice Scalia with the Cornhusker hypothesis.